Every institution checks the other two. So if judiciary is supposed to exercise an objective, rational check on the working of the executive and the parliament, it has to be independent from both the legislature, that is the parliament, and the executive, right? Otherwise, this principle of separation of powers or this principle of the subsequent principle of checks and balances can never be operationalized. Now let's come to the more, I would say, the climactic portions of our discussion on this chapter of judiciary, the real issues that confront our judiciary. And one of the more recent ones obviously has been that this allegation has come against the present government, that it has been trying to emasculate the judiciary, and not just judiciary at any level, possibly even the Supreme Court. So a bit of a question mark has been placed against the independence of judiciary, in particular that of the Supreme Court, and more especially in the tenure of some of the previous Chief Justices, one of whom actually even accepted the position of Rajya Sabha membership. So we'll discuss all those issues as we go along. So a lot of issues to be discussed with respect to issues in judiciary. This is the larger part of our discussion. Plenty of issues to be discussed. One by one we'll take them up over here. Right. So obviously the first issue we are discussing over here is judicial independence, right? You can always get this question because, well, this allegation of emasculation of our judiciary, especially at the highest level, has been discussed and debated for the last two or three decades, or 2 or 3 years, so to speak, perhaps even a little more than that. So this is a question which is very relevant, which can come at any point of time in the mains also, right? So the first question obviously could be that, why is it that in a democratic country, and particularly in a democratic country like India, why do you even require judicial independence? So if this question comes, what points have to be articulated? Judicial independence, why is it required? Now look at the first point I mentioned over here, principle of separation of powers and checks and balances. But if your country's constitution is based on separation of powers, and separation of powers naturally entails another principle called checks and balances, which means every institution checks the other two. So if judiciary is supposed to exercise an objective, rational check on the working of the executive and the parliament, it has to be independent from both the legislature, that is the parliament, and the executive, right? Otherwise, this principle of separation of powers or this principle of the subsequent principle of checks and balances can never be operationalized unless the judiciary is independent from not just the legislature, but more importantly from the executive itself, right? So the principle of separation of powers, checks and balances can never be operationalized without judicial independence. Secondly, our problem is that very often we blame the judiciary for this huge pendency of cases, which today they are saying runs into around 4.5 crore cases. I'll be dealing with that issue today itself. A lot of criticism of judiciary, it is inefficient, it is not working properly, there is such huge pendency. One, and when I'll discuss pendency today itself, I'll be, putting this issue of pendency in the right perspective itself. I mean, it's very easy to blame the judiciary for what is happening, right, when it comes to this piling up of cases. Correct. Understand one thing, especially in the higher courts, High Courts and Supreme Court, almost 50% of cases which are pending over there, government is a litigant. Yes. And one of the reasons for high levels of pendency in the High Court and Supreme Court is this also, that government has been somewhat of a irresponsible and compulsive litigant. It's involved in so many cases. Either it is involved because somebody has complained against the government in terms of rights violation, etc., or the government is pursuing a case against some individual company, corporate house, etc. So we'll talk about that as we go along, right? But the problem is this now. If government itself is a litigant before the courts, and if the courts are not independent from the government, so then there is a clear conflict of interest. You can see this thing. Here is a government which is itself one of the party to the cases before a judge, yet that judge is not independent from that very government, which is the executive. How will he be able to take a dispassionate and objective view of things? Because government, all over the world, you will find in democratic countries, that government is also involved in a spate of litigation which is pending before the courts. And if that court is under the influence of that very government, so the judgments of the court will also be biased towards the government only. You got the idea? So because government itself is a major litigant before courts, we cannot broker a situation, that situation is unacceptable where the courts are under some kind of controlling influence of the government. Therefore, they need to be independent. Second point. Then of course, one of the most solemn duties of the court system, especially at the higher court level, is to uphold the constitution and to prevent any kind of unwarranted invasion of the constitution by not just the parliament but also by the executive. how can such action of the executive and parliament be checked, where the parliament or the executive are engaging in actions or passing such laws which are violative of the constitution, violative of fundamental rights? If the judiciary is not independent of them, it can never protect the constitution against such unwarranted invasion, right? So another reason why we require judicial independence is to uphold the constitution and protect it from unwarranted invasion, both by the legislature and the executive, right? And then, we have to understand one thing. The parliament makes the laws, executive enforces the laws. But the people in the legislature who make the laws and the ones in the executive who enforce the laws are themselves not above that law. They often tend to become, but they are not supposed to be above that law. They are also subject to the same rule of law as, of course, are the people, the ordinary private citizens in the country. Now, to preserve, protect rule of law, that all those individuals and citizens living in the country, howsoever high they may be, the law is always above them. To implement this principle, if the judiciary is not independent of the executive, then they will not be able to apply the notions of rule of law to members of the executive. You got the idea? If there is a case in which a senior ranking government official or minister is involved, and he has to be prosecuted as per the law of the land, it would become difficult for the judiciary to do so, because if the judiciary is under the controlling influence of that very government to which that minister also belongs, right? So to implement rule of law impartially, whether you are a high placed official, whether you are a part of the government or whether you are a private citizen, whether you are a part of legislature or a private citizen, rule of law has to be implemented impartially. This can be done only when the judiciary is independent of those high and mighty, those powerful figures and officials and ministers who belong to the executive, and those big grand leaders who are part of the legislature, right? So to preserve the rule of law, simple point, let's move further. To preserve rights of people, obviously that is there. We find this thing that most of the writ petitions which go to the Supreme Court or the High Courts for that matter, in many cases, these writ petitions are usually against some government action which has led to deprivation of some fundamental rights of some sections of people or some individuals, right? So, if the complaints, writ petitions of the private citizens with respect to fundamental rights violations are largely against the government, and if the judiciary is not independent from the executive or the government, then people's rights would never be protected, because they would naturally be biased towards the government which is actually violating rights, right? There are innumerable situations, as I said. In most cases, you find that most of the writ petitions which are filed, fundamental right violations cases which are filed, they are usually filed against state authorities only. So, if the state authority is having controlling influence over the judiciary, then judiciary will never be able to pass an objective rational decision in such cases, and rights of the people would be obviously eroded, right? So, to preserve the rights of people, some time back I mentioned this thing, that the judiciary, especially at the higher court level, High Court and Supreme Court, plays a very important counter-majoritarian role. I think I used this expression earlier in one of my lectures also. Understand one thing, I'll repeat this thing. Just because a ruling party has a clear majority, especially at the center, it does not mean that it can do anything, right? And this is a kind of thinking which is actually pervading the present government, that it can practically do anything, right? Even unmindful of the constitution, unmindful of the judiciary, unmindful of the highest court of the land also. But that is something which the courts are supposed to check. This is a very important aspect of philosophy of working of the courts in modern democracies, that the courts have to play a very important counter-majoritarian role. What is that? See, to counter the majority government to prevent majority government from doing some illegal things, some wrong things, immoral, unethical things or irrational things, there is a check on the government which has a clear majority. That check is at the first level exercised by the opposition parties. But opposition parties are in a minority in the two houses of legislature, at least in the more decisive house, that is the Lok Sabha, there they are in a minority. So there is a limit up to which they can prevent such actions of the majority government. Then another institution which is supposed to check such illegal, unethical actions on part of a majority government, that is the media. But sometimes the media also becomes what it has become today. Media may also fail. So if the opposition fails, if the media fails, and yet the government is hell-bent on, a majority government is hell-bent on taking some illegal actions which are flirting with the constitutional norms and constitutional boundaries, somebody has to check them. Somebody has to counter this majoritarian government. So who will do that? It is the courts only that can do that. Only when the courts are independent of the judiciary is independent of the executive, that it can actually play a counter-majoritarian role against the government. As I said, that there is another statement which is made in this context. ठीक है भैया, democracy means rule of majority, but democracy does not mean tyranny of majority. Right. So this counter-majoritarian role of the courts is relevant in this context, that the court has to prevent majority governments or democracy from degenerating into the tyranny of the majority, right? So it's not that once you have a clear majority in the two houses of the parliament, you can practically do anything, unmindful of the laws, unmindful of constitutional norms, constitutional provisions and articles, etc. Somebody has to check you. If the opposition cannot check you, if the media cannot check you, if people's movements cannot check you, andolans cannot check you, the court comes into the picture to play that counter-majoritarian role, checking a majority government. It has a clear majority, yet it is not entitled in a democracy to do practically anything. So the court's role is over here to ensure that democracy does not degenerate. It's a rule by majority. So rule by majority should not degenerate into tyranny of majority, right? So this counter-majoritarian role, the apex court or any court in a democratic country can play only when it is independent of the executive, right? Then judicial independence is also required to preserve federal polity. ठीक है ना भाई? Judiciary has to be independent from state government also, central government also. But if the judiciary is, and usually in all federal setups like India, there are disputes between center and states. And those disputes fall under the original jurisdiction of the Supreme Court. You are well aware of that fact, right? Now, what if the judiciary is under the controlling influence of the central government? So, in a dispute involving central government and the state governments, on which side the balance of justice will tilt? Obviously, with the central government, right? And if there are so many occasions where the state governments, they claim that the central government is invading into their territory, central government is trying to encroach upon their domain, their constitutionally assigned functions and subjects under Schedule 7, etc. So these cases go to the Supreme Court. Supreme Court has to make sure that in the working of a federal polity, state governments don't step into the domain of the central government, and central government does not do so with respect to the state government, right? But this it can do so if it is independent of the government, both at the center and the state level. Then only it can preserve the norms of federal polity. And then in general, a lot of things which the bureaucracy and civil servants do, very often they are corrupt actions, very often they are abusive actions, very often they are actions which lead to violation of rights of people, harm the interests of people. So judiciary has to check all those things, which it can do only when it is independent of the executive. Read over here with me. So judicial independence is required to check on the part of the executive malfeasance, misfeasance, nonfeasance. FEASANC. What is malfeasance? Abuse of power. A willful act of abuse of power, unethical use of power, which naturally leads to harm coming to public interest or some specific individual. So what is malfeasance? Abuse of power. Now, abuse of power by government or government officials can be checked by the courts properly and effectively if the courts are independent of the government and their officials. This is malfeasance, clear abuse of power with a willful intent. Achha, sometimes, a civil servant did not intend harm, but because of some error, carelessness, negligence on his part, some error took place, some harm was brought to an individual or some public interest was harmed, but that was not a willful act. If it was a willful act, that is malfeasance. That is direct with malafide intent, you are trying to abuse your power. And that brings some harm to to public interest or some specific individual or groups of individuals, right? But in misfeasance, the harm may be there. Some section, some public interest may be harmed, may be hurt, some individuals may be hurt, but there was no willful intent. It was on account of negligence, a genuine error, a mistake, carelessness, etc. That falls in the category of something called misfeasance. Because harm to has been done na. So who will check malfeasance, abuse of power against the government and government officials? The courts. Who will check misfeasance, where there was no willful intent, but yet some harm took place and it was not appropriate that this harm should not have taken place? Again, the courts will come in, right? And nonfeasance. Achha, nonfeasance is, where a public servant, civil servant, police official, anyone, in a specific situation, he had the authority and the responsibility to act, to protect the people, for example. He failed to act, and that led to violation of rights of the people. So what is nonfeasance? Nonfeasance over here is that there was a situation where under law, you were required to act, you had the authority to act, you had the duty and the responsibility to act, you failed to act, right? So if a cop or a public official refuses to, or he has, on account of any pressure, it could be political or senior officials' pressure, he refuses to act or does not act in a situation where he was required to act under law, it was his duty and responsibility. And because he did not act in that situation, it brought some harm, it brought some violation of some rights of some sections of people or individuals. So that also can be checked and corrected where? In the courts only. So the courts can, appropriately check things like, this is nonfeasance, where a person, a public servant was supposed to act, that was a matter in his jurisdiction. It was not just his authority and power, but his duty and responsibility to act. He refuses to act or he fails to act. So that or the such cases can also go to the courts, and courts will then correct them and obviously administer corrective action, right? So judiciary has to be independent if it has to check malfeasance on part of the executive, misfeasance on part of the executive, nonfeasance on part of the executive. Often there is another term called overfeasance. Overfeasance is non-feasance to is na ki you fail to act in a matter which is falling under your jurisdiction. Overfeasance is you go beyond your jurisdiction. You didn't even have the right to act in that particular area, yet you pronounce an order in that area. So there again, where will you go? You will go to the courts only, and that order which is beyond jurisdiction of a particular public service, public servant or public official will be nullified, right? Another term is overfeasance also, right? So you can also use another term, overfeasance. So malfeasance, misfeasance, nonfeasance, and you can also add one more, that is overfeasance, which means exceeding your jurisdiction, right? So the reasons as to why we require judicial independence. I hope these are clear. If this question comes, these points would be sufficient.